the record? Already in the record?
No, you may.
Just summarize.
Yes, please.
Basically, what the court needed to deal with in this matter was simply that is there any risk that this witness is facing or is likely to face after his face or her face being shown on TV. The likelihood of a prejudice, was there prejudice to be suffered? Thereby the court has a duty to apply its discretion on whether indeed there's a prejudice that this witness is going to suffer. I'll just quote, and then it says on paragraph 12, the court held further that a mere conjecture or speculation that prejudice might occur ought not to be enough. It follows therefore that an applicant who seeks for the court to restrict the media in the manner the applicant seeks to do has a burden to show court that such a risk not only exists, but that prejudice is most likely to be brought to bear against him or her. So we have not had what risk except to say this person is in business, is in the transport business. So that judgeship does not bear any risk of him losing business. In fact, he's going to get more business. So it does not bear any prejudice on him. In fact, it's going to gain it. My contention is that there is no risk of any prejudice that the witness is going to suffer, or any of the witness is going to suffer. That's part of the issue. That's my contention.
Okay, that's what I mean. I don't know what you come on that I don't have any reporting. Now, that much form. That is the issue that people spoke as you just be. The on being able to do the don't mean the way of the they took the having. Then they are like idea and don't mind to anyone from what you but no, just got to know that. We are not on the Bambo from the Shoki, that one of family and one another. But in fact, that people are with open to the business and to get about that and get that show of the problem. But I, my case is good. You must be taken a walk more than they are. I don't know my that.
What does that indication now for this restriction, which my colleague has only indicated one witness that seemed to be having a problem with him being shown on Now, what about the other witnesses? Because initially I had my colleague saying the witnesses do not want to be shown. Now, the only base or reason given to the court is in respect of one witness, and the other ones, nothing is said about them. The court will find now the power to make to exercise this discretion in section 1532 of the Criminal Procedure Act deals with these restrictions, which the section clearly also indicates that there should be an indication of potential harm and such harm that might result from a witness's testimony. Now, we don't know if this witness that has or currently has business or transport business, his testimony will have any effect in as far as this bill is concerned, and is that the harm sufficient to restrict if we show. I think Matala is the third umbrella measure. In that case, the court emphasized that the court will only The court will only restrict broadcast if a real risk of prejudice to a witness is demonstrated and not speculative. Very important. Should not be speculative. Only in those circumstances that the court will say this witness will not be shown on TV. Their names are known, they have been given, and there isn't any base that we see or find from the submissions made by my colleague that there should be such restrictions. And we'll then ask the worship that they should not be done. They should be broadcast on this day. Unless there is anything that.
Thank you.
Thank you.
Thank you, Worship. Can I have the check sheet? There's a purpose. Before I make a ruling, I just want to confirm and verify the media which is present here and any media institution which previously did not bring an application to broadcast and record these proceedings must indicate their presence in these proceedings now so that we can deal with it. Capricorn, newsroom, SABC, ENCA, Namibia, News 24. Any other media present here? Who are they? Yes, who are those institutions? MDNtv.
That big one.
And the other one?
The Post newspaper, the local newspaper.
The Post. Local.
Yes. And Nepal Floriana.
I'm sorry?
Nepal Floriana South Africa is 24.
Thank you. The proceedings of this matter was in this court on the 26th of November 2024, and also was postponed. Was on the roll on the 7th of October 2024 and postponed to the 26th of November 2024. And on the 26th of November 2024, it was then postponed until the 19th of May 2025. And from the 19th was then postponed until today. During these proceedings, previously the media was present, and they make application that they should be allowed to broadcast and also to film the proceedings of this particular case. The defense representing the accused were involved in that particular application, and there was no objection from the defense representing the accused to that effect. The court granted the application for the media to broadcast the proceedings of this case. It was from the beginning very clear that there was no objection whatsoever from the defense or the accused that the broadcasting of these proceedings will prejudice them. If there was any objection, particularly regarding prejudice on the part of the accused, if the proceedings may be broadcasted, the court will have dealt with that issue and make a ruling as regards to whether the broadcasting of films should proceed or not. I specifically indicated that I will deal with the issue as to whether the position will be the same in as far as the witnesses are concerned. Hence the state application today to the effect that they apply that the witnesses not be televised or filmed, but however their evidence may be broadcasted without their identity being disclosed.
Este todo no compaguri ni orang mau berpagi kalau kita tidak mencaci na hal itu jadi bagi di kami kau pemakaman mau apa marah atau juga kau cakap kumbang gua atau nunggu di belakang tahu rekod nunggu mana mau sesuatu itu kembali pakai mau pemakaman kau mau berpagi kalau kita tidak.
Interestingly, the defense now says no. If the court allows that the witnesses should be protected to that extent, therefore it should also apply to the accused, even if there is no prejudice of whatever nature from the accused side, just because the court, if it can allow to say the witnesses' names should not be disclosed, their faces too, then it must also happen to the accused.
Bapa kita tahu bahwa di Malaysia mereka sini, jadi kita bukan numpang dua tahun kan dua di Ceyong kan, mereka mau numpang dua tahun tahu bahwa kon macam lagi, Malaysia itu, nak kasih nak tahu apa nama tani uang nak dia orang tani uang nak, habis dia tahu apa orang kerja, tahu kita masih bukan tahu orang macam ada nama apa.
If I were to approach this from that angle or argument, I find it without merit, and I find that it would not be valid because of the fact that the court will allow, will grant the state an application not to disclose the names of the witnesses and also not to broadcast them, particularly their faces. Therefore, it should be allowed to the accused. There was no prejudice whatsoever that has been argued on behalf of the accused as regards to that fact.
Dapat kamu tidur dapat kamu tidur. Kasih kalau si macam itu kamu jadi jadi kamu jadi. Oh si kena ujar awalnya bagi tadi kamu tidur mana punya nak kamu kamu si macam orang apa macam macam kerja di dalam itu.
I agree with what the defense is saying as regards to what was said in the case of Breka versus Media 24 Limited and others. 2017 ZA SCA 97 delivered on the 21st of June 2017 that unless the prejudice is demonstrable and there is a risk that such prejudice will occur, mere conjecture or speculation that prejudice might occur out is not to be enough.
Anak kita ni kan bangku mana, anak kita dengan mana kami boleh kita bekerja. Kemudian tahu tuan bekerja, oleh mak, bagi jalan juga di lokal mana.